May I seek
Yes.
your lordship indulgence in making a mention of part 2, item number 15 and 16.
What happened?
My lords, if the matter can be taken up on 1st of October.
You are for the appellant
Yes,
in both the matters?
yes, my lord.
Is your name here in the cause list?
Yes, my lord, Lal Ropari.
Okay, heard Miss Lal Ropari, learned counsel for the appellant, who has prayed for adjournment of the matter. In view of the above list,
1st of October.
in view of the above, as prayed for, list on 1/10/2024. Yes, then in item number 16, heard Miss same date,
Yes, my lord.
and as prayed for, list on 1/10. Yes. Mr. Johnny, you
Yes.
want a name to be reflected?
Not necessary, Lordship. Yeah.
Okay. Yes.
I'm deeply obliged.
Lordship, part 2, item number 11. This may be taken up on 3rd or 4th, Lordship.
Heard
Whichever-
Ms. Johnny L. Totsong, learned counsel for the appellant, who has prayed for adjournment of the matter and for listing the matter on, when do you want it?
3rd, Lordship, if possible.
3/10/2024.
Lordship.
Yes. Accordingly, list on 3/10, so and so.
Part 1, admission, item 1.
Lordship, in this matter, in the last court date, Mr. H. Zodin Sanga, learned legal aid counsel, prayed sometime for filing the counter affidavit. I was informed that he was not feeling well today.
Okay. Mr. Johnny L. Totsong, learned counsel for the petitioner, is present, while Mr. H. Zodin Sanga, learned legal aid counsel for respondent number 8, is absent. Full stop. It is seen that the learned counsel for respondent number 8 is yet to file his counter affidavit. Yes, state anything to mention? Okay. Miss Linda, then full stop, then Miss Linda L. Fumble, learned government advocate, learned additional AG, is present and submits that they have filed their counter affidavit. In view of the above list, after the ensuing vacations.
Item 2.
My lord, I'm for respondent number 2, and paper book has been received, and if this matter may be listed for hearing in due course.
Is it? Okay, heard Miss
Ruth Dalwatfeli.
Ruth. Well, your name is not reflected?
It's here, my lord.
Where?
Last second, just above baby Lalvin Hui, in item number 2.
Okay, heard Miss. I thought it was the appellant who was making
I'm
the
for-
mention. Yes. We'll just say the learned counsels for both the parties are present. It is seen that paper book is prepared and duly furnished to both the parties. What about respondent number 5 and 6?
No need to issue formal notice for respondent number 5 and 6.
Why? Who's representing 5 and 6?
Mr. Zoram Chana.
Lordship, I'm on his behalf.
Okay. Though the office note dated 23/09/2024 reflects that steps are yet to be taken for service of notice upon respondent number 5 and 6, Mr. Lelrenzwala appears on behalf of his senior, Mr. C. Zoram Chana, to represent respondents number 5 and 6. In view of the above, it is seen that all the parties are duly represented and the matter is to be listed for hearing in due course.
Item 3.
My Lord, in this matter, respondent number 6 and 7 has been newly implemented, and a notice was issued on the 20th of August. And I believe the ID card has,
So we'll have to wait for some more time, isn't it?
yes, and my Lord, and regarding respondent number 7, there has been a mistake in the address. So if your lordship will be allowed to make the amendment at the registry.
Okay, heard Mr. Jonathan L. Sowler, learned counsel for the petitioner, who submits that the address of respondent number 7 needs to be corrected, and pray that he may be allowed to issue fresh notice upon respondent number 7.
My Lord, the,
Is it?
Yes.
7 is what? Northeast Frontier Railway, Tarapur, Silchar.
no, that is the wrong address. That was the earlier deputy CE address. It should be Kolpuri. They have, now they have a separate office at Kolpuri.
Okay, submits that he may be allowed to file a corrected cost title
My Lord.
with the correct address of respondent number 7, and that he may also be allowed to issue fresh notice upon respondent number 7. Praise aloud. The learned counsel for the petitioner is to take necessary steps and matter is to be listed after the ensuing vacations. Now, what about 6?
6 is correct, Your Lordship.
Okay, so we are still awaiting.
We are still awaiting 6. Madam, my Lord, the respondent number 7, his office and his station there in Kaunpur only. Should we do Dusty or?
Well, issue notice first in the correct listing through registered post. Okay.
Give
Yes.
the oblige, Your Lordship.
Item 4.
Yes. None appeared for the parties on call. List after the ensuing vacation.
For order. Item number 5.
Yes.
Lordship, we have done as per your Lordship direction. So, my Lord, this at least,
Wait, so what happened?
So-
Dusty served?
yes, Lordship.
Let's see the affidavit. This is in the IA.
Yes.
Yes.
Yes, my Lord. One of my preliminary submission is that I have a long compilation. May I please,
But usually, when you pray for suspension of the sentence, you have to convince the court
Yes.
that there will be sufficient grounds.
exactly,
prima
that's why allow
facie-
me to give
yes,
the chance to satisfy the court,
Prima
Lordship.
facie that there is a likelihood that
Yes.
the person will be acquitted of the charge,
Before I
isn't
submit,
it? Yes.
the main appeal was Lordship admitted.
Yes,
already
has it been admitted?
Yes,
Yes,
Lordship.
it has been admitted.
Yes.
Ah, so
So, my
what are
lord-
your grounds?
Before I go to the merit of the case, I would like to submit before three important points where the Honorable Supreme Court passed order in respect of sentence suspension. So, Lordship, I have furnished the judgment Bakwan Ram. Even in my application also, I mentioned this ruling also. If you kindly see SCC Supreme Court judgment, 1994, volume 4.
You have a copy or
I have furnished
you have furnished me a
Yes,
copy? Wait,
yes.
let me see.
SCC copy.
SCC
1994, volume 4.
1994. Is it
Very- very short.
1999? I think it is
Now,
1999.
first I want to refer 1990. Sorry, Lordship, I beg your pardon.
1999, yes.
Volume 4.
Yes, yes.
Only one page. That's, here, conviction is for 10 years. Only Parachi. May I please read only Parachi?
Yes.
When a convicted person is sentenced to a fixed period of sentence, and when he files an appeal under any statutory right, suspension of sentence can be considered by appellate court liberally unless there are exceptional circumstances. Of course, if there is any statutory restriction against suspension of sentence, it is a different matter. Similarly, when sentence is life imprisonment, the consideration for suspension of sentence could be of a different approach. But it is for any reasons for the sentence of a limited duration cannot be suspended. Every endeavor should be made to dispose of the appeal on merit, more so when a motion for expeditious hearing of the appeal is made in such cases. Otherwise, the very valuable right of appeal would be an exercise in futility by efflux of time. When appellant court finds that due to practical reason, such appeal cannot be disposed of expeditiously, appellate court must bestow special concern in the matter of suspending the sentence, so as to make the appeal right, meaningful, and effective. Of course, appellate courts can impose similar conditions when bail is granted. So here, my submission in respect of this case, pertaining to our very present case, is that we know the situation. So CBI, though they have two standing counsel who contested effectively in the trial court, special court, they are very unable because CBI, when they appoint their standing counsel, they are very careful, competent, and lots of parameters are there. So here also they have their counsels. We had served 2 times already. Even at the times of motion, in a similar case, in another accused also, they knew that. They knew very well that they did not come. Now advertisement is going on. They are not care. So how can we dispose of this appeal expeditiously, even they receive it? That is one of my points. Even normally, we know the practice in our court. Normally, appeal takes time, especially PC Act. This is one of my grounds, without going to the merit of the case. Even I highlighted these provisions also, this judgment also in my pleading also. Secondly, KC Sarin. This exactly square feet in my case, because the accused, the petitioner here also a bank officer, a bank manager. SCC 2001,
Yes.
volume 6, 584.
Oh, have you supplied me a copy?
I have supplied.
No. Yes or no? This
I
is
think,
2001 6 SCC 584. Is it this? No.
I think along with my petition, I
Wait,
supplied
let me see.
2001, volume 6.
If you have supplied me a
2000.
copy, we don't have to search for it. In your petition, you have,
No, I have compilation of judgment,
oh,
and behind that, it must be there.
behind what? We find your compilation of
Yes.
judgments.
In a separate sheet. 2001, volume 6.
Yes.
The very brief fact of this case is that the bank manager who was accused of misappropriations of the fund was convicted by special court. He applied for suspension of sentence along with conviction. So the High Court all of a sudden suspend only sentence, not the conviction. He had gone to appeal, and again he had gone back to High Court, and again this is second round. This is the observation. So, Lordship, allow me to go to 11. Para 11. This is the ratio. Legal position, therefore, is this. Though the power to suspend an order of conviction apart from the order of sentence is not alien to Section 3891 of the Code, its exercise should be limited to very exceptional cases. This is exceptional cases. It's referred to suspension of conviction. But in my case, I pray for suspension of sentence only. Merely because the convicted person files an appeal in challenge to the conviction, the court should not suspend operations of the order of the conviction. The court has a duty bound to look at all aspects, including ramifications of keeping such convictions in abeyance. It is in the light of the above legal position that we have to examine the question as to what should be the position when a public servant is convicted on offense under
So you
PCA.
have prayed only for suspension
Yeah,
of
in
the
my case.
sentence,
Yes.
isn't it?
Yes.
Yes, so read that portion which is
Yes.
relevant.
No doubt when the appellant court admits the appeal filed in a challenge of conviction and sentence for the offense under PC Act, Superior Court should normally suspend the sentence of imprisonment until disposal of the appeal, because refusal thereof would render the very appeal onerous unless such appeal could be heard soon after the filing of the appeal. But suspension of conviction of the offense under PC Act, like therefore the sentence of imprisonment as a sequel to thereof, is a different matter. So what is here held is that suspension of sentence should be normally done, but suspend of sentence should be in a different approach. In my case, I pray only suspensions of sentence.
Okay, yes,
also
okay, we'll allow.
All right, Lordship.
Because though dusty service has been served to the respondents, in spite of that, they are again absent, isn't it?
Yes,
So it appears that they have nothing to say in this matter. And if I have not mistaken, no one is appointed to represent the CBI in the High Court.
Yet,
So the only counsel they have is for the district court. Yes, heard Mr. JC so-and-so, learned counsel for the applicant who has filed the instant application for suspension of the sentence order passed by the learned special court dated. Where's the judgment, date of sentence, not the judgment?
1/7/2024.
Wait, let me just find the page. This is the
Lordship,
conviction.
199. It start with, in my application, 194. It start from 194.
Sentence order dated 01/07/2024 on the conviction of the applicant, while the judgment and order dated 28/06/2024 in SR within brackets PCA close bracket number 05 of 2012, reference CBI C/number RC-7 within brackets A 2010-2010, all in capital, IMPH, dated 22/11/2010, under section 120B, read with 420, it will be read with section, okay, 420/468/471 IPC, and under section 13 within brackets 2, read with 13 within brackets 1 within brackets C within brackets D of PC Act, wherein the applicant was sentenced
$199. 4 years.
Yes, where
It is
is it
199, Your
mentioned?
Lordship.
What
199.
199, page 199. But I'm looking at the application and your synopsis. I think I'll have to look at the order. Sentenced to undergo 4 years imprisonment with a fine of rupees 10 lakhs in default, another imprisonment for 2 years. The learned counsel, new para, the learned counsel for the applicant submits that the criminal appeal number 35/2024 has been admitted, and though notice is served to the respondents through dusty service, the respondents have failed to appear before the court. The learned counsel therefore submits that since the respondents have not been represented till date, there is every likelihood that the disposal of the criminal appeal number 35/2024 is likely to take some time. The learned counsel further submits that, is he innocent?
Yes, innocent.
The applicant is innocent of the charges made out against him, which will be proved during the consideration of the criminal appeal number 35/2024. He further submits that there is no likelihood of the applicant absconding during the consideration of the criminal appeal. Yes, where is he residing?
Actually, here, New Lamka, in the post title, GS Road, Gaus Kupve, New Lamka.
Where is that? In Manipur?
Manipur.
Then, does he have a resident here somewhere?
Yes,
Or what?
Dorpui Veng. Their families are Zel Veng.
Since he is residing with his family at Dorpui Jail Wang Aizon. Full stop. The learned counsel, in support of his submissions, has cited the decision of the apex court in Bhagwan Ram Sinde Goshai and others versus State of Gujarat, reported in 1999 4 SCC 421 and in KC Sareen versus CBI, Chandigarh, reported in 2001 6 SCC 584.
Ma'am, please.
Wherein,
Lordship,
yes,
case is Karin versus CBI. I think you
yes,
have mentioned Chandigarh, sir.
CBI Chandigarh,
All right. Yes.
isn't it?
Yes, correct.
Wherein the apex court had pointed out that the sentence for an offence under PC Act should normally be suspended till the disposal of the appeal. The new para. Having heard the submissions made by the learned counsel for the applicant, this court, on considering the fact that the respondents have failed to appear in spite of notice being served upon them, find that there is a possibility that the criminal appeal number 35/24, which has been admitted, is not likely to be disposed of in the near future on the non-representation of the respondents. Full stop. This court also finds that since it appears that there is no likelihood of the applicant absconding during dependency of the criminal trial number 35/2024, find it appropriate to suspend the sentence order dated, copy paste, okay, passed by the learned, so copy paste the whole thing. And accordingly, grant bail to the applicant under section what of the BNS? Under section, what is the new section?
430, 430,
430 of the
BNSS.
yes, BNSS Act 2024. Okay. Of the BNSS, 2024. With a bail bond of rupees 1 lakh and with one surety of the like amount, who shall be to the satisfaction of the learned trial court. Accordingly, IA numbers 44/2024 stands allowed and disposed of. Yes.
Much obliged.
Now, in the main criminal appeal, Mr. J.C. London Sanga, learned counsel for the appellant is present. It is seen that none appeared for the respondents, though notice has been duly served to the respondents through dusty service. In the absence of the respondents, list this matter after the ensuing vacation. Yes.
Much obliged, Lord.
Item 6.
My lord, I'm appearing on behalf of Mr. Jonathan, the counsel for the applicant. He's having some personal difficulty, so if the case may be taken up after a week.
Mention is made on behalf of Mr. Jonathan Lalrentwanga, learned counsel for the applicant, for adjournment of the matter, since the learned counsel is not able to appear due to some personal difficulties. Full stop. In view of the above, list this matter in the next week.
Yes, my lord. Oblige.
Item 7.
Yes.
My lord, the registry has listed as sooner than we had anticipated. However, he was taken to civil hospital on Friday. That we have, and I believe that the civil hospital OPD card is again reviewed by the jail medical. So we did not have that. We went this morning, and then we even asked him, and he said he doesn't have it with him.
So when will you be ready?
My lord, the civil OPD we can submit that. And my lord, and also the acknowledgement from the storekeeper who used to get the flour and the rice from the applicant, that they're gonna send the acknowledgement and some documents. That also, it's on the way.
It's on the way.
Yes, my lord.
Then we'll fix some other date. You
Yes,
see,
maybe.
because we want to see whether your case is really genuine or not.
Yes, my lord. My lord,
Because
it
the
is-
amount
it
of
is.
seized article, it's, I think, methamphetamine or what? Or
Yes.
heroin?
It's
What is the
methamphetamine.
Ah, a huge amount of methamphetamine, so we cannot take it lightly,
Yes,
isn't
my
it?
lord.
Yes. But if there is a genuine case, then we have to consider that also.
Yes, my
isn't
lord.
it? Yes. So you get all your required documents by the next date,
Yes, my lord. My lord, if it may be fixed.
and whether he's fit to be kept in the jail, that has to be seen.
Yes, my lord.
Okay. Yes, heard Ms. Lalngai Sakifana, learned counsel for the applicant, who was prayed for further time to produce the necessary documents in the instant bail application. Yes, in view of the above, lists
My lord, if it may be listed on 26th.
on 26th, 9/2024. Yes.
Deeply obliged.
Item 8.
Yes, who's appearing? What is the IA about?
My lord, it's a condonation of delay. It's an
Of how many
application.
days?
88
89 days.
88
Yes,
days.
89 days. So notice is complete?
It's complete, my lord. The grounds have been put forward and Lordship may kindly condone the delay.
So here, it says that unserved notice is returned with a note that insufficient address,
My lord.
isn't it? So who's the respondents? They all are from Aizon?
They are from Aizawl and they are living in the same building, my lord.
But it says that, see, your address is residence of Bongkon, Aizol. Now, Bongkon, Aizol is a huge area,
I understand.
isn't it? They must be having some house number or some, area within Bongkon having a, just residence of Bongkon. It will be very difficult. So get the correct address, isn't it?
Yes, my lord. I will take fresh steps.
Yes. Heard Mr. Rokung Apautu, learned counsel for the applicant, who submits that in view of the office note dated 17/09/2024, wherein it is reflected that notice upon the respondents could not be served due to insufficient address, he submits that he may be allowed to issue notice to the respondents in the corrected address. Praise aloud. The applicant is to take necessary steps. List after the ensuing vacation.
My lord, kindly allow me to utilize the unserved copy, if lordship permits.
As prayed for, the learned counsel for the applicant is allowed to utilize the unserved copy for issuance of fresh notice upon the respondents.
Obliged.
For hearing, item 9.